Welcome to Motivation at Hand. To know is to know how. Make your foot the foot that counts. Chicago, January 24, 2024. In hallowed halls where knowledge thrives. Elite institutions, where dreams take their dives. A lawsuit unfolded, a tale of great might. Of universities accused, in a legal fight. The plaintiffs stepped forth, their voices raised high. To challenge the practices, they deemed awry. 16 esteemed schools, their claim did decry. In the court's stern gaze, they sought to rectify. Allegations of favor, the wealthy did sway. In admissions, they said, an unfair display. Collusion they argued, in a devious array. Competitive secrets, exchanged in dismay. Prestigious universities agree to $118 million settlement in admissions lawsuit. Chicago, January 24, 2024. In a major development. Brown University, Columbia University, Yale University, Duke University, and Emory University have collectively agreed to pay a staggering $118 million to resolve a lawsuit that accused them of favoring wealthy applicants in their admissions processes. This landmark settlement comes as the culmination of a legal battle initiated by a group of plaintiffs, including Andrew Corzo, Sia Henry, Alexander Leo Guerra, Michael Mayerlender, Brandon Piaevsky, Benjamin Shumate, Brittany Tatiana Weaver, and Cameron Williams. One of the defendants remains undisclosed, who brought the case before the United States District Court for the Northern District of Illinois under case number 122 CV00125. Allegations of unfair admissions practices. The lawsuit, which sent shockwaves through the education sector, alleged that 16 elite universities, including those in the settlement, violated antitrust laws by colluding on a common formula and principles regarding financial aid. Plaintiffs contended that these institutions exchanged competitively sensitive information concerning financial aid principles, formulas, and pricing. The plaintiffs specifically claimed that the universities conspired to restrict financial aid, violating their pledge not to consider students' finances in admissions decisions, and thereby giving an unfair advantage to wealthy students. Settlement details. In the latest turn of events, Brown University, Columbia University, Yale University, Duke University, and Emory University have agreed to pay substantial sums to resolve the case. Brown University will contribute $19.5 million to the settlement, while Yale and Emory University will each pay $18.5 million. Columbia and Duke University have committed to paying $24 million each, bringing the total settlements to $118 million. The University of Chicago and Vanderbilt University had. It is essential to note that the settlement amount for Vanderbilt University was previously reached settlements in a related 2022 case, which alleged significant tuition overcharges in violation of U.S. antitrust law. Legal proceedings and societal impact. U.S. District Judge Matthew F. Kennelly, who presided over the case, declined to dismiss the lawsuit in 2022, allowing it to proceed. The plaintiffs have now proposed a comprehensive schedule for the remainder of the settlement approval process, including provisional certification of the proposed settlement class, provisional appointment of the plaintiffs as class representatives, and preliminary approval of the proposed second tranche settlement agreements. From a societal perspective, this case highlights critical issues surrounding wealth inequality, access to higher education, preliminary approval of the proposed second tranche settlement agreements. It underscores the role of prestigious universities in shaping educational opportunities and the potential consequences of alleged collusion among elite institutions. The outcomes of this case are expected to have far-reaching implications for discussions on fairness and access in American higher education. Next steps. While this settlement represents a significant step towards resolving the admissions scandal, it is essential to note that the settlements are pending final approval by U.S. District Judge Matthew F. Kennelly. Plaintiffs' lawyers have expressed hope that these settlements will set a precedent and Encourage other institutions to address concerns related to overcharges for middle class and working class students. This breaking news continues to evolve. In this groundbreaking case that has sparked nationwide conversations about equity and fairness in higher education. In the midst the legal battle's fervent fight. Universities and students in the spotlight. The journey's not over, more steps to contend. For justice and fairness, they still must defend. Much appreciation to you for giving of your time with us at Motivation at Hand. To know is to know how. We trust you will come back soon.